Welcome back. Decades after suffering and even dying from silicosis and tuberculosis, mine workers are still fighting to receive compensation. While the Supreme Court has dismissed an appeal by two mining companies to challenge a 2016 High Court ruling, the court certified a class action against the gold mining industry in South Africa for harm caused to mine workers. 19 companies reached a historic settlement with mine workers and their dependents, which led to a settlement estimated to be around 5 billion rand. However, DRD Gold and East Rand Proprietary Mines Limited decided to litigate rather than to settle. Director at Richard Spoor Attorneys, George Khan, speaks to us now about this and give us some context and clarity. George, thank you so much for your time and good morning to you. I suppose let's start here for those who need to catch up a bit with the case. Give us some context. How did we get here?
Good morning to you, your viewers, and all the possible class members listening out there. Just to indicate where we are, I mean, essentially, as you indicated, what happened is we did manage to accomplish a historic settlement with the vast majority of the gold mining companies, including Harmony, Anglo American SA, and so on. But DRD Gold Group, which consists of DRD Gold itself, as well as East Rand Mine, which is one of the oldest mining companies in South Africa. Its mine, it was established in the 19th century and predates the Union and the Republic. They indicated, decided that they were going to persist with the appeal against the certification. And that matter then came to a hearing last year. The court heard the matter and essentially decided the matter on the basis that a certification of a class action is not appealable at this juncture in time. What that means where we are currently is DRD Gold obviously has an opportunity and an entitlement to petition the Constitutional Court, whether they want to further appeal the decision of the SCA, failing which the class action is to proceed. And it is to proceed against them on behalf of gold mine workers who were exposed to unsafe levels of dust underground in their gold mines and then developed and contracted silicosis, which is an incurable and progressive disease.
I mean, I also want to touch on the impact that has had on mine workers, on their family members, most losing their lives, some having, I can imagine, you know, chronic illnesses right now. Just take me through the impact, rather, George, on silicosis and, you know, those who have suffered under those working conditions.
Unfortunately, silicosis is somewhat a remnant and the legacy of apartheid to a large extent. It was because of the apartheid legislation that many mine workers were forced into dangerous and unsafe mining conditions. They had no other choices in order to support their families, and the dust conditions were only started to become regulated in 1965, where a prescribed maximum level of dust was instituted. And what happened as a result is, even despite that prescription in terms of maximum levels that were allowed, mine workers were exposed to unsafe levels. What that resulted in is them developing silicosis, which can progress to what legislation sometimes refers to second-degree silicosis. And a second-degree mine worker is not able to work. They're declared unfit for working. And typically, they would not find any other kind of employment anywhere else. And that would result in severe poverty issues for themselves and their families. What is important to understand in this case as well, and what the Supreme Court of Appeal also had consideration, but again decided it was not appealable at this stage, was the question of transmissibility of general damages.
Right.
What that means is whether a person's personal pain and suffering can be transmitted to their estate and their dependents prior to the close of pleadings, which is an old procedural concept in our law. Why that is important is because we have now recognized, or the High Court has recognized with the assistance of amicuses that came and joined the matter, that there is certainly a gender issue at play here as well. Because what inevitably happens is these migrant mine workers will frequently go home with this medical condition that results in them eventually losing their lives. Their health is terrible, and someone at home ends up having to look after them. That is usually widow or the daughters or the mothers and so forth, which means then that those women have to defer their own futures, their own education, their own employment, which then traps them in a cycle of poverty. So the disease has far larger and longer lasting implications than simply the life of the mine worker themselves.
Yeah.
And as I've indicated, I mean, my view is that this is essentially a legacy of apartheid that we are trying to resolve.
So, George, what's then the obligation of DRD and ERPM right now, especially with what you've just mentioned, the picture you painted of the realities of this many families, the widows, the kids, the children, the grandmothers, the loved ones, the mine workers themselves that are still alive yet have to live with these health conditions. What's your hope in terms of the obligation of DRD and ERP right now?
I think our hope at this stage is that we don't have to end up in a protracted, long and costly litigation process. In the Supreme Court of Appeal, the legal representatives of DRD actually suggested that we would actually take at least 5 years if the matter would proceed straight to the action phase before we would be able to obtain a trial date. And that is in nobody's interest, especially considering the fact that 4% of mine workers, in our estimate, pass away each year. It is our hope that DRD Gold Group, which includes Eastran, will return to the negotiating tables where they once were and come and sit down with us to try and arrange settlement as what the other gold minings did when the other gold minings recognized their corporate social responsibility in this respect. And I mean, let me just point out what is interesting in this particular matter is one of those companies that has settled was Sibanye. And Sibanye at the present moment, in actual fact, the majority share owner of DRD Gold. So there's something interesting there as well. But I'm very grateful to Sibanye that they did the right thing. They've settled. Their mine workers are being compensated through the trust that has been set up. But what we need to do is we need to resolve those that work with DRD Gold in respect of those that only work for DRD Gold, which does occur in many cases, but also those that work for DRD Gold and some of the settling mining companies. And the reason for that is, well, the trust that was established will compensate those workers for the time that they spent on the settling mining companies. Right. It cannot compensate them for the time that they spent on DRD Gold. They are still missing that portion of their compensation.
Well, George, I appreciate you speaking to us about this and putting this matter to the fore. Thank you so much. George Khan, we appreciate your time this morning right here on the South African Morning. George is the director at Richard Spoor Attorneys.